After Mr. Carr spoke, I thought I decided not to speak to make the presentation because I agreed wholeheartedly with him. But after Mr. Jason, I thought I would have to speak as government and at the last word. That's why I'll go through the presentation. I thought I was not going to go through it. I'm not going to go into details in terms of the background. Most of you are aware of where we come from with the contracting system since 1966. I thought I would, like the content indicator, I would just highlight some of the issues that has led us to believe that Section 197 should be considered to be applicable in the contracting environment in the way we do our contract on the buses. Just to give you a brief background of where we come from, prior to 1996, operators had lifelong permits. And then with the white paper of 1996, the competitive tendering was then introduced. In the transition, there was, in 1997, government signed interim contract in preparation for tenders. Those interim contracts were supposed to run for 3 years, which was supposed to be out to tender by the year 2000. 1998, the first tender contract was issued, and then in 1999, the tripartite agreement was signed between government, the industry groups through SABOA, and organized labor unions. And in 2000, we then introduced, through the National Land Transport Transition Act, we introduced the negotiated contract. In 2002, as you can see, there was an amendment to the Labor Relations Act of 1995. Section 197 was amended. And as Mr. Kais indicated, in 2011, there was a constitutional judgment that now changed the way we understood the application of Section 197. With the introduction of tendered contracting in 1998, when tendered competitive tendering came into being, the employment of workers who were working for bus contract were terminated and they were re-employed, and there was a lot of uncertainty. The net effect was that there was massive drop in wages, the reduction in the employees. Also, operators started competing on the cost of labor, because as Mr. Jessamine has indicated, in some instances you have cost of labor running above 24% of your total business cost. So labor became a hand in the sandwich, as they say, because operators, for them to win tenders, you had to reduce your cost to be competitive, and then the only area where most operators competed was on the labor cost. I borrowed this slide from one of the presentations by SABOA following a research that was done by the West Business School on the effect of the tender system on labor. Most of the employment conditions were negatively affected. Issues of employee morale, labor peace, a whole list of issues that were negatively affected by the introduction of the tendering system, because workers felt that they were not protected enough. So the whole list here, the issues around wages and benefit, retention of skilled workers, the performance of work in general, all these issues were negatively affected because the workers felt that they were not protected enough, so they had to renegotiate their benefits and the wages when a new contractor comes in. Now, in the midst of things, a tripartite agreement was then signed in 1999. It was called the Terms of Agreement. This agreement was intended to govern issues of labor when you move from the transition from the interim contract to tendered contract. It broadly regulated issues around job security, subcontract, retrenchment. For example, it provided that when a new tenderer comes in, was supposed to take over 75% of his required workforce. So it was intended to protect to a certain extent the workers in the working environment. It was not, unfortunately, based on continuity of employment. It assumed that there will be a clean break and whoever comes in will have to re-employ the workers, and then those workers will have to negotiate their own benefits. And as we indicate on this slide, the intention of the heads of agreement was not to diminish the right of workers. In fact, it was intended to secure the rights of workers. Unfortunately, it has proven not to be successful in handling critical labor issues. Now, organized labor then requested that there should be a review of this heads of agreement. Since 2000 up to date, parties, government, labor, and SABUA spent a lot of time trying to resolve these labor issues within the heads of agreement. Mr. Hayes usually calls it the heads of disagreement, because from the day it was signed, there was little agreement. In fact, there was more disagreement in the agreement in how it is supposed to be implemented. Like I'm saying, up to today, we're grappling with how to deal with those critical issues that have been raised by labor in the heads of agreement. The problem for us is, when you look here, even to the extent where it wants to protect the labor, it is only applicable in the first round when we move from interim to tender. In there, as Mr. Kai has indicated, we have made a provision that whoever comes in is forced to take over 75% of his required workforce, meaning that you have the forceful takeover of the workers, which when you read the recent, I'm not a legal person, but some people might say it then triggers in the application of Section 197. Our problem is when you move from tender to second round of tendering, there is nothing that protects the workers. In fact, the idea was that we should sign another agreement that will then protect workers when we move from the tender to tender, because the heads of agreement only applies in the first round when we move from interim to tender. Our position is that we don't need another agreement. Section 197 of the Labor Relations Act, as it is being interpreted currently, covers the workers when we move from tender to tender. I'm not going to, this is an extract, Mr. Kai has gone through it in detail, what the Section 197 of the Labor Relations Act says. I just want to go to the issue of the purpose of the Section 197. In fact, the primary objective of the Labor Relations Act is to give effect to the rights that are entrenched in the Constitution. One of those rights is Section 23(1), which dictates everyone has the right to fair labor practice. That right cannot be limited to people. It will apply across the board, including those workers who work for companies or businesses that will change hands because of a contracting arrangement. And our understanding is that any law or any conduct that is inconsistent with the Constitution is invalid. So we are saying, against this background, we should look at the scope of Section 197. How do we apply it is another issue. The provision of Section 197 should be interpreted within the provision of the total act, the Labor Relations Act. The purpose of the Labor Relations Act is to promote economic development, social justice, and labor peace. And we are saying how we interpret Section 197 should go with one, the purpose and the context in which that section is found. Section 197 is located in Chapter 8 of the Labor Relations Act. Chapter 8 deals with unfair labor practice, including dismissal, unfair dismissal. Now, it also covers the issue of automatic transfer of employees in cases where the business changes hand. The issue, one opinion, Mr. Jesselman, when you say an opinion is an opinion, was that it doesn't matter how the transfer happens. Transfer can happen through a tendering process, it can happen through a contracting arrangement. What is of importance is the consequence of the transfer. If that consequence of what occurs is defined as a going concern, then Section 197 will apply. And the primary objective of Section 1 is to protect the employees whose security of employment or their right is jeopardized when you move businesses from one person to another. So the objective is to protect workers against job losses. 197 pushes for continuity of employment of workers, so that when we put when we put contracts out, it does not interrupt the continuity of employment of people who have worked for many years in those companies. In line with that, the objectives of the Labour Relations Act and the purpose and the spirit of the Constitution, we believe Section 197 should apply, because it outlaws the unfair dismissal of workers. I'm not going to go into this constitutional court judgment. I think Mr. Kai has indicated. This constitution, the judgment was based on whether 197 applies in what is called the second generation. But there are principles that we believe can be used overall in our situation. One is that Section 3 of the Labour Relations Act obliges any person to interpret that act in line with what complies with the Constitution. We cannot interpret. If we go to challenge this in court, it will be based on whether we are interpreting it the correct way of interpreting Section 197 of the Labour Relations Act. It pushes that the rights that are enshrined in the Constitution must be enjoyed by both the workers as well as the employers. Now, it achieves those problems. We agree that those purposes that are preserved in the Act might differ between the workers and the employers, but it is upon us to make sure that it works. When you compare the provision of Section 197 and the agreement that we signed in 1997, there's a glaring conflict between the two. We accept today that the HOA was signed not with the intention of diminishing the rights of workers. Unfortunately, it offends the provision of Section 197 of the Labour Relations Act. Now, as I've indicated, where we got quite a number of legal opinions which says where an agreement seeks to regulate the continuity of employment for workers who are affected by a transfer of business, then the provision of Section 197 automatically triggers in. In this case, that's where we are saying, in our contracting environment, in the past contract, we should make sure that Section 197 applies. This is how we look at it. It will protect 100% workers, give 100% job security for workers when you move from interim to tender, even when you move from tender to tender in the second and subsequent round. Section 197 will protect the workers 100%. Now, I had Prof in the morning indicated some of the critical issues, the challenges for applying Section 197. And I agree with what Prof has indicated, that there are huge challenges that we will face. Issues around how we design this contract, issues about sensitivity of information, some of the challenges that has been raised by Mr. Jesseman also. We agree there are those challenges. But we are saying the transactions that were envisaged when parties signed the HOA are all governed by Section 197. There is no need for us to sign another agreement. Government has a general responsibility to respect the constitutional right of workers. We also have the social and general responsibility to respect the constitutional right of the employers to conduct business. Now, in this case, it cannot be right to say, because it is difficult to apply Section 197 in our environment, because there are a lot of problems to apply it. Those problems that we acknowledge, that it will not be an easy process. We cannot say it is right to say because of those problems then we cannot apply it. It cannot be right to say You cannot apply the law because the law is difficult to apply. The law will remain the law. It is upon us to make sure that we make the environment conducive for employers to comply. It is the responsibility of government to create an enabling environment that will facilitate the smooth transition to make sure that they comply with Section 197. This can be achieved in many ways. As I said, it will not be an easy process, but we can look at the way we conduct our tenders. The tendering process obviously will have to change to make sure that operators comply. We might have to look at things that we can include in the tender document. How we design our tenders will also make sure, will also have to be reviewed to make sure that we allow the operators to be able to comply. Issues around the sensitivity of information. All these problems that have been raised, that we agree that there are problems allowing us to comply with Section 197, will have to be dealt with in an organized and responsible way. But what we are saying is that we cannot say because of those problems we will not comply with the law, because the law will remain the law. It is upon us to make sure that we comply. This is the view from government, and for us to be able to answer all these questions that have been asked in terms of how do we comply, government will lead that process together with the industry, organized labor. We will have to look at the systems and make sure that the systems allows tenderers and operators who will be competing to be able to apply. Thank you.